Good evening, everyone. I'm Professor Michelle Foster, the Dean of the Melbourne Law School, and it's my great pleasure to welcome you to the 2024 Harold Ford Memorial Lecture. I'd like to begin by acknowledging that we're meeting this evening on the unceded lands of the Wurundjeri people of the Kulin Nation, and I pay my respects to elders past, present and emerging. And I extend this acknowledgement to all Aboriginal and Torres Strait Islander peoples joining us today. Now, tonight's lecture is part of a series that honours one of Melbourne Law School's most distinguished and loved alumnus, the late Harold Ford. And you will hear more shortly about Harold Ford's long and distinguished career and the very significant contribution that he made to Melbourne Law School. But for now, I note that in addition to this lecture series, Melbourne Law School honours Harold Ford's legacy by offering the Harold Ford Scholarships, designed to assist JD students in financial need. I'm very pleased that we're joined this evening by Harold Ford's son, John Ford, and John's partner, Kate. It is wonderful to have members of the Ford family with us at this special event. So welcome, John and Kate. I'd also like to offer my gratitude to Clayton Utes, who have once again partnered with Melbourne Law School to offer the Harold Ford Memorial Lecture. I acknowledge members of Clayton Utes here tonight and welcome them to Melbourne Law School, and in particular Andrew Walker of Clayton Utes, who will kindly close proceedings tonight with a vote of thanks. Now, this evening's event is extra special because we're celebrating the 50th anniversary of Harold Ford's Principles of Corporation Law. Therefore, in addition to our esteemed keynote guest speaker, the Honourable Justice Mark Leeming, we'll begin with a short presentation by one of the text's current authors and himself a much-loved professor at MLS, Professor Ian Ramsay. But now I'm going to hand over to Professor Rosemary Langford, who will introduce our speakers and will also facilitate the Q&A discussion at the conclusion of tonight's formal presentations. Professor Langford is the Melbourne Law School Harold Ford Professor of Commercial Law and also the Director of the Melbourne Centre for Commercial Law. So thank you, Rosemary.
Thank you, Michelle, and welcome everyone. So it's with great pleasure tonight that I introduce Redmond Barry Distinguished Emeritus Professor Ian Ramsay AO to present a special tribute on the 50th anniversary of Harold Ford's seminal textbook on corporations law. I doubt that Ian needs any introduction to you, but I'll note that he was previously the Harold Ford Professor of Commercial Law at Melbourne Law School and also Director of the Centre for Corporate Law, which was the predecessor of Melbourne Centre for Commercial Law. Ian's published extensively on corporate law both internationally and in Australia, and he currently co-authors Australia's leading corporate law text, Ford, Austin and Ramsay's Principles of Corporations Law, which is of course the modern version of Harold Ford's original text. Thanks very much, Ian.
Thank you very much, Professor Langford. Well, I'm very pleased to have been asked to speak to you just for a few minutes this evening about Professor Harold Ford, in whose honour this evening's lecture is given. Professor Ford was an extraordinarily influential scholar, teacher and law reformer. Justice Julie Dodd-Streeton, who was a student, co-teacher and close friend of Harold Ford, has described him as the undisputed founding father of modern Australian corporations law. Harold Ford was born in Melbourne in 1920 and grew up during the Great Depression. He enrolled at the University of Melbourne as a 16-year-old in the Article Clerks course. Naval service from 1939 to 1946 interrupted his studies. He won the Supreme Court Prize for Article Clerks in 1948, and in 1949 he became the 5th member of Melbourne Law School's full-time academic staff. In 1960, he was appointed Robert Garran Professor of Law at the Australian National University and Foundation Dean of the Faculty of Law. He returned to Melbourne in 1962 as Professor of Commercial Law and was Dean of Melbourne Law School in 1964 in Sir Zelman Cowen's absence, and from 1967 to 1973. He retired from the University of Melbourne in 1984 and for approximately the next 10 years was a consultant at Clayton Utes. Professor Ford played a very prominent role in the development of corporate law in this country. He was a member of important law reform committees. The first was the Manning Bills of Exchange Committee, whose report led to amendments of the Bills of Exchange Act. The second was the Task Force on a National Companies Bill. That committee produced the 1975 National Companies Bill. Between 1976 and 1978, Professor Ford chaired a corporate affairs stock exchange joint working party which recommended the establishment of a central clearinghouse system for settling transactions on the stock exchange. From 1984 to 1990, he chaired the Companies and Securities Law Review Committee, the federal government's independent corporate law reform advisory body. It can therefore be seen that Harold Ford has had a profound influence upon the direction of Australian corporate law through his contributions to law reform. Professor Ford's influence has also been felt through his many widely respected publications, and perhaps most notable is his book on company law, of which I will say a few more things in a moment. But his other books included Principles of the Law of Trusts and an introduction to the Securities Industries Acts. He also published many journal articles. Professor Ford received a number of awards. The University of Melbourne conferred on him the honorary degree of LLD in 1987. Before that, in 1977, he became a Fellow of the Academy of Social Sciences in Australia. In 1994, he was made a member of the Order of Australia for Services to Law. And it was in 2000 that the Society of Corporate Law Academics conferred its first honorary life membership on him in recognition of his outstanding achievements as a scholar, educator, and reformer. When Professor Ford retired from the University of Melbourne at the end of 1984, the Law Institute Journal marked his retirement with a feature article in which it was stated, "He is universally admired and respected, both for his scholastic and professional expertise, as well as for his basic humanity and kindness." For Professor Ford's 80th birthday, Melbourne Law School organised a conference with many distinguished speakers from academia and the judiciary. The proceedings were published as a book titled Key Developments in Corporate Law and Trust Law, Essays in Honour of Professor Harold Ford. The foreword to the book was written by Justice Kenneth Hayne of the High Court of Australia, who was a student of Harold Ford, and who said in relation to his research, "All of Professor Ford's work has been marked by the relentless questioning and intellectual rigour of the scholar. It has been the measured, incisive, and above all, deeply considered contribution to the fundamental consideration of principle which has marked his work. Few in Australia have made the contribution to legal scholarship that he has made over the years." I wanted to say a little bit more about Professor Ford's book on company law, and that is because, as we heard from the Dean, this year is the 50th anniversary of the publication of the first edition of Principles of Company Law. The book has had a remarkable history. 17 editions have now been published, and a more detailed version of the book is published as a 3-volume print and online edition. Professor Ford was the sole author of the first 4 editions of the book. He was later joined by co-authors. It is perhaps particularly worth mentioning that Professor Ford kept writing for this book until he was 88 years of age. The 15th edition of the book contains a tribute to Professor Ford, who had passed away the year before. And it's stated in the tribute, "Professor Ford's work has made a fundamental conceptual contribution to company law. About 6 generations of students across Australia and beyond are in his debt for his many insights. Since his ideas are embodied in the subject, his influence will continue wherever Australian corporate law is taught." To assess the influence of the book, a citation report was prepared this year by the Law Library of Melbourne University. And according to that report, the various editions of the book have been cited in over 800 judgments of courts, including the High Court of Australia, the Federal Court of Australia, and the Supreme Courts of all Australian states. The book has also been cited in overseas courts, including courts in Singapore, Hong Kong, and the United States. But in addition, the book has been cited in over 700 journal articles. When Professor Ford first published Principles of Company Law in 1974, It is, I think, unlikely he would have anticipated the significant influence of the book. Indeed, he may have thought it unlikely that 50 years later the book would be in its 17th edition and there would also be a 3-volume print and online edition. Practitioners, academics, students, and others who practice and study Australian corporate law are indebted to him for his pioneering scholarship. For those of us who had the pleasure and the privilege of knowing Professor Ford, we appreciate that neither his keen intellect nor the affection with which he was held dimmed over the years. As Justice Dodd Streeton wrote, his life touched and enriched so many, and he will be remembered as a gifted and generous scholar, teacher, and friend. Thank you very much.
Thanks very much, Ian. Well, now I have the pleasure of introducing our keynote speaker, and I would just note that after our speaker has finished, we will have time for question and answers, so please save up lots of questions. So our keynote speaker tonight is, of course, the Honourable Justice Mark Leeming, Judge of Appeal of the Supreme Court of New South Wales. A University of Sydney alumnus, Justice Leeming was appointed to the Court of Appeal in 2013 after practising at the New South Wales Bar since 1995 and as senior counsel from 2006. He went to the bar after completing associateships under the renowned Chief Justice Sir Anthony Mason and Justice William Gummo of the High Court of Australia. He's been Challis Lecturer in Equity at the University of Sydney since 2004 and also maintains the capacity to be a prolific author of journal articles across constitutional law, administrative law, equity, trusts and legal history. He's the co-author of the texts Resolving Conflicts of Laws, The Statutory Foundations of Negligence and Authority to Decide, the Law of Jurisdiction in Australia. He remains a member of the editorial boards of the Journal of Equity and the Australian Bar Review and is Honorary Bencher of Lincoln's Inn. So welcome to Melbourne Law School, Justice Leeming. It's a real pleasure to have you with us. Thank you.
Well, thank you very much, Rosemary. The first thing to say is my gratitude to the university and the organisers for offering me the opportunity to speak tonight. This is one of the most prestigious occasions that this country offers to honour legal scholarship. The standards that my predecessors have set are ferociously high. I'm going to do my best not to let you down. I'm also very grateful for Ian saying those words. It's most appropriate that we remember the man in whose honour we're gathered this evening, and my misfortune through age and geography was never to meet Harold Ford. I'm not sure whether this counts, but I'm going to give it a go. My wife is a product of this university, and after she graduated, she was an article clerk at Clayton Utz, and she told me about 2 hours ago, more timing would have been helpful, that a group of the article clerks, and I'm sure she won't mind my saying this, and I get the strong sense they were the nerdy ones, would hover around Harold's office in the building. And she gave 3 descriptions of the man. Revered, just imagine youth looking up to this truly grey eminence, eminent and impeccably polite. I thought I should share that with you. Now, there's broadly speaking 2 sorts of addresses a judge can make on an occasion like this. One is what I call a judicial homily, shedding insight into some point of law or what the judge is thinking about or some recent judgment or some question of practice. And those sorts of speeches are immensely interesting to quite a few people. They're immensely interesting to advocates who desperately want to know, more than anything else, what makes a judge tick and get insights into what submissions are likely to find favour in that human, fallible, judicial brain, and what submissions are not likely to find favour. And it's also intensely interesting to those who are commenting on the product of courts It gives them insights into why we've got to where we are and what's likely to be coming in the future. It's also quite useful for the judge because it's a way of communicating extrajudicially what's on his or her mind, including communicating to his or her fellow judges. And if you've got something to say, it's quite easy to write, and it's quite easy to listen to, because after all, the point is to get across a simple message. But it's not serious scholarship. And everything I know about Harold Ford suggests to me that he would have wanted this occasion to be one of serious scholarship as opposed to judicial homily. So that's what I've sought to do. Sorry, it's harder work for you. It's hard in a few ways. The content is difficult and the paper is long. And I'm not going to read 12,000 words to you, even if that were an appropriate thing to do in the 35 minutes I've been given. Actually 31 minutes and 40 seconds that are remaining to me. So what I'm going to do instead is attempt to present, knowing that you don't have it before you, what this paper is about. It will get published, I hope, in the reasonably near future, and you can walk away thinking, well, that's one paper I'm never going to read, or maybe that's one paper I might be vaguely interested in reading. I tell you it has two parts. The first part is headed Varying Accounts of the Birth of Company Law, and the second part is headed Varying Accounts of the Ways in which Courts Use Judgments. And there's a conclusion, and I'll give you the conclusion in full, but I warn you in advance it won't make complete sense because I don't have time to give you all of parts 1 and parts 2. But let me tell you something about its flavour. Here are some of the questions that the paper investigates. Why are directors sometimes called trustees? Why do we sometimes speak of company law and sometimes of corporations law, with the emphasis of the former upon multiplicity and the latter upon a body, a singular body? Why does the knowing recipient of company property from a director in breach of duty hold that property as a constructive trustee? Can it possibly be right that, and I quote, a credit in a company's bank account which the directors are authorised to operate are monies of the company under the control of those directors and are held by them on trust for the company in accordance with its purpose? It also asks whether it could possibly be right to say that in the nanosecond before a director gives effect to his or her breach of fiduciary duty, misapplying company property, then and there, something called an equitable beneficial interest springs into existence such that the third party getting the company property only receives legal title and the company retains that equitable beneficial interest. Now, many of you in this very distinguished audience, which honours me and Harold, will recognise that one of those quotes is a much quoted statement of Justice Ungood Thomas from Selangor United Rubber Estates and Craddock 55 years ago. And the other is a rough summary of Lord Briggs' reasoning about 11 months ago in the UK Supreme Court in Byres and Saudi National Bank. Another theme of the paper is what Benjamin Cardozo would have called the method of history. And I want to put to you that that happens all the time, much more commonly than we think. Another is how indispensable a contextual understanding of how the law works and how it's developed is to any seriously arguable question of law that's being debated in the 21st century. Now, the title of the paper refers to the use and misuse of principle. I've framed it that way because that's how language works. We could talk about this fraying red old tie, but it'd be much more sensible to talk about this old red fraying tie. English is full of unspoken rules. One of my favourites is the rules about adjective order, which are quite difficult even to formulate. Judgments are full of unspoken rules as well, which can be quite difficult to formulate. But I want to get one thing straight at the beginning. It's mostly about the misuse of principle, not the use of principle. I'm not saying that misuse of principle is endemic. Far from it. I don't think there's very much, but as it happens, as we all know, the interesting cases, the ones that are worth commenting upon, are ones where something's gone wrong. Now, I've ummed and ahed about this fourth last flavour of this 12,000 words that aren't going to be read to you, but I'm going to say it anyway. Although one of the themes is things are complex. But if there was one sentence which summarised the point the paper seeks to convey, it's this. In most litigation involving a contestable question of law, it will normally suit at least one side to contend that some earlier decision should be read literally rather than contextually. Those sorts of submissions can be very powerful, and they may very well be correct, but you've got to be careful, because it's quite possible that that's how the law is going to be distorted, and the advocate is doing so in the best interest of his or her client, but in truth, the words of that particular judgment aren't meant to bear their literal meaning. If there were two things I was going to say about this paper, the second would be this paper can't be summed up in one simple 10-second slogan. So that's the flavour of it. Let me get into it. The first part, varying accounts of the birth of modern company law. The birth of modern company law, well, you think of companies legislation between 1844 and 1856 in a place on the other side of the world. Authors who use that term nonetheless tend to be conscious that the history extends back to medieval guilds, chartered corporations, deed of settlement companies. Any approach which starts with those 19th century English statutes as the foundation necessarily suffers from two limitations, geographical and temporal. There are these colonies in Australia which were doing their own thing, and they tend to have been understudied, although I've set out in the footnotes some very healthy 21st century developments on that front. This is an aspect of what Paul Finn once called, I like the phrase, a colonised cast of mind. A lot of recent work is rectifying gaps in both company law and across the legal spectrum, but that's not what this paper's about. This paper is about the temporal limitation of focusing upon some English statutes in the mid-Victorian age. Now, if you take as the premise that a sensible description of the birth of modern company law commences in the mid-19th century, then the relationship between directors and trustees is easily explained. And here's Gower's account. I'm quoting, "It's often stated that directors, in addition to being agents, are also trustees. It's easy to see how this idea arose. Prior to 1844, most joint stock companies were unincorporated and depended for their validity on a deed of settlement, vesting the property of the company and the directors as trustees for the members. Hence, the directors were, in the fullest sense, trustees, and it was right to describe them. With incorporated companies, this description wasn't strictly appropriate, but it wasn't unnatural that the court should extend it to them by analogy." The paper contends that that explanation is attractive and coherent and quite misleading as a general account of how directors came to be regarded as trustees who owed fiduciary obligations. Back to my theme, beware of easy explanations. That is not to deny the utility in some situations of focusing upon the 19th century developments. There's a chunk of historiography and the efforts, the remarkable articles of both Keaton and Seeley on the director as trustee, which I'm going to pass right over. And we go to within the last year, Lord Briggs in the UK Supreme Court in Byers and Saudi National Bank. He described the following point. He said about knowing receipt, which in its traditional form depends upon there being an original trust of the relevant property and a split between legal title and beneficial ownership. That doctrine works in relation to many reported cases in which a company or its liquidator seeks to pursue the remedy after a transfer of company property at the behest of its directors acting in breach. In such a case, the company starts out as legal and beneficial owner, and courts of equity have proceeded upon an analogy between the control which directors as fiduciaries have over company property and the title which trustees have to trust property, so that a misapplication of the company's property by the directors leaves the beneficial ownership with the company for the purpose of equitable proprietary claims and claims in knowing receipt. And His Lordship says the best known attempts to explain this conundrum are Justice Ungood Thomas in Selangor United Rubber and Justice Buckley in Belmont Finance. Now, the conclusion in that appeal late last year was that a Saudi Arabian law which gave clear title to a third-party purchaser of shares transferred by a knowing recipient of those shares operated as a complete defence to the beneficiary's claim for knowing receipt. As presently advised, the position in New South Wales is exactly the opposite. And there are 4 decisions of the Court of Appeal in the footnotes. But the correctness or otherwise of bars isn't my point. The point is that historical questions, such as the analysis given by Lord Briggs in appellate courts, continue to matter. And advocates continue to put this sort of analysis to appellate courts when contestable questions of law arise. And I go on to give various examples of this. And this is what Benjamin Cardozo called, or an aspect of, I think, the method of history. One of the points I want to hammer, though, is that you don't have to be in the High Court of Australia or an Intermediate Court of Appeal ultimately arguing a really important question of law. This notion of understanding the legal meaning of judges' reasons for judgment is quotidian. Every time you look at a case, you really need, in order to understand it, to understand what the context is. So John Baker put it well. He said, quote, "We need to be able to switch our minds over to the same thought processes as the lawyers of the period in which we're working." Now, then there are some very interesting pages. There's a 15th century account of the birth of corporations law, and I talk about ecclesiastical law and the law of British boroughs. And absolutely fascinatingly, did you know Oxford, the University of Oxford, had been making contracts in its own right for about 2 centuries before there was ever a charter? Sort of completely the reverse of what you might think. One commentator referring to this ancient law said that there was a mature form of English corporations law by 1659, when the first big book on corporations law was published. That casts a little bit of doubt upon a theory that this was all dreamed up in 1844 and thereafter. These corporations were different. On the whole, they held land and stone buildings on the land. But there's one exceptional case, although it comes from a little bit later in time, that fits into this part of the picture. And that's the decision that Justice Edelman regarded as the first major decision and probably the most influential concerning the duties of company directors. And of course, this is the charitable corporation in Sutton. It does the corporation down to call it that. Its true name, under its Royal Charter of 1707, was the Charitable Corporation for the Relief of the Industrious Poor by assisting them with small sums at legal interest. So this is micro-lending in the early 18th century. And so it was a corporation that lent money and dealt with assets in a way that a charitable corporation that just owned a church or a college didn't. And that led to abuse by its office holders and Lord Hardwicke's judgment, and I just want to read you a little bit of that. He talks about the committee men. He says they're most properly agents to those who employ them in the trust and who empower them to direct and superintend the affairs of the corporation. Now, where acts are executed within their authority, in such cases, though attended with bad consequences, it'll be very difficult to determine that they are breaches of trust. For it is by no means just in a judge, after bad consequences have arisen from such executions of their power, to say that they foresaw at the time what must necessarily happen, and they were therefore guilty of a breach of trust. And then he goes on to talk about malfeasance and non-feasance and the different ways in which trust obligations adhere. Now, that's many centuries ago, but you can see, even then in Lord Hardwicke's reasons, a sensitivity to what we today call the business judgment rule, the problems of reasoning with the benefit of hindsight, and an account which deals with the way in which directors are agents but owe equitable obligations, which necessarily are framed in terms of trust, because the word fiduciary wasn't in circulation at the time in that sense. There's then a section which deals with a 17th century account of the origins of company law, which talks about the East India Company, the company of the staple, and my favourite, the company of merchant adventurers. These are chaps who go off and sell things and buy other things and make money. One of them was dealing with the Russian Tsar, and the deal was that the sovereign would give these chaps the exclusive right to trade in a particular geographical location or in a particular commodity like wool. And so it's actually deeply ironic for those people who think that the modern corporation is a laissez-faire institution. It's deeply grounded in monopolies. In fact, it's been argued that monopoly became, quote, an almost inherent characteristic of the early business corporations and a major factor in their future development. This is where we get the first use of the word director. A parliamentary inquiry in 1604 about the Muscovy Company described it as follows. The Muscovy Company, consisting of 8 score or thereabouts, have 15 directors who manage the whole trade. These limit to every man the portion of stock he shall trade for, make one person stock of it all, and consign it into the hands of one agent at Moscow, and so again at their return to one agent in London. A whole company, by this means, is become as one man. This is the notion of joint stock, which is the key distinction between joint venture and corporation. I'm going to skip over the East India Company and something which was the last thing to fall on the cutting floor this morning. Pacioli, a confidant of Leonardo da Vinci, familiar to some of you for his work on perspective, but I've reproduced bits of his work on, wait for it, double entry bookkeeping. The reason for that being that some scholars make a persuasive case for the fact that until you have double entry bookkeeping, you can't properly separate the accounts of the firm from the accounts of the partners. So the accounting development, so someone, brackets an accountant, says, was a necessary, indispensable component of the birth of the modern corporation. I also skip over, for present purposes, the 18th and 19th centuries, which are far more familiar to you here today. What emerges from the overview, the paper proceeds to say, is that the conception of the typical corporation changed substantially over the centuries. One commentator says, a typical 17th century corporation was an overseas trading corporation, such as the East India Company. A typical 18th century corporation was a financial corporation, such as the Bank of England or the South Sea Company. A typical late 18th century corporation was a canal company. A typical mid-19th century corporation was a railway company. And I would add a typical late 19th century company was one incorporated pursuant to the Companies Act 1862 and probably had only a small number of shareholders. And then the paper deals with something that Harold Ford would have been interested in. He did his doctoral thesis at Harvard with Austin Scott on unincorporated associations. And he and Frederick Maitland and Samuel Stoljar saw wisdom when trying to chart the history of these things called companies or corporations to look at how the law treated unincorporated bodies. And their works, which I deal with, are set out in some detail. I got onto Maitland when I was teaching a trust course at Sydney University about 15 years ago, and I said a quote from it in an exam. And I think it's the only time that the Australian Financial Review has run an article on a law exam. They did so. I remember getting the call from Michael Pelly. Did you really set this exam? I said, yes, I did. So here's the question. Maitland says, if a foreign friend asks me to tell him in one word whether the right of a destinar is Dinglish or obligatorisch, I should be inclined to say, no, I can't do that. If I said Dinglish, that would be untrue. If I said obligatorisch, I should suggest what was false. Ultimately, it might be obligatorisch, but for many practical purposes, it's been treated as though it were Dinglish. And indeed, people habitually speak and think of it as a kind of Eigentum. Discuss. The question was optional. Some people answered it. The Fin Review quoted me correctly as saying, a student who chose to answer that question and didn't focus on the fact that the beneficiary of a trust had both personal and proprietary rights, something which doesn't fit well with continental law systems, shouldn't expect to do well. An F for hearsay then. you can see my obsession with definitions and language has been around for some little while. Part A of the paper concludes with 2 sentences that there are many ways in which an account of modern company law can be told. To say that it was born in the mid-19th century is a very substantial simplification. Part B talks about the varying ways in which courts deploy earlier cases. So let me just go back to the reasons of Justice Ungood Thomas in Selangor United Rubber Estates that were relied upon 11 months ago in the UK Supreme Court. A credit in a company's bank account which the directors are authorised to operate are monies of the company under the control of those directors and are held by them on trust for the company in accordance with its purpose. Sometimes we just have to call things out. It's nonsense. It's palpable nonsense, isn't it? The credit in the company's bank account is nothing more and nothing less than the debt that the bank owes the company. The company owns the debt. The directors don't own the debt. The directors don't own the debt as trustees. If a student had written that in an answer at any institution in this country, you would hope they would be failed. Lord Justice Buckley, dealing with reliance upon that heresy in the second Belmont Finance case, was much more restrained, much more English, much more polite than I've just been. He said, a limited company is of course not a trustee of its own funds, it's their beneficial owner, but in consequence of the fiduciary character of their duties, the directors of a limited company are treated as if they were trustees of those funds of the company which are in their hands or under their control. And if they misapply them, they commit a breach of trust. There is a world of difference between saying you are a trustee and you're treated by the law as if you're a trustee. And I deal with Australian cases which have it correctly right, New Zealand cases that seem not to understand how heretical Justice Ungood Thomas was. Why did Selangor United Rubber Estates get to that position which, when you unpack it, it seems to me, is just nonsense? He commenced his reasons as follows. On occasion, directors have been said to be trustees, and on occasion not to be trustees. Like so many interminable arguments in philosophy, economics, and everyday life, its resolution depends largely upon definition of terms, in this case of trustees, and then on the ambit of its proper application to directors. What had happened was that counsel had bowled up to him in an argument faced with a Barnes and Addy claim, saying, here's what Lord Selborne said, trustees. We're not trustees, therefore we can't be liable. It's a paradigm example of the difficulties in reading the words of a judgment literally rather than contextually. The words of judgments are not to be construed as if they're statutes. Justice Ungood Thomas then recited a passage from Justice Romer in Re City Equitable Fire Insurance that's antithetical to his conclusion, to the effect that directors were trustees can be accepted if it means no more than that they are fiduciaries, but otherwise it can't be accepted. So Justice Romer was absolutely clear about this. Justice Ungood Thomas also cited 3 19th century judgments, 2 of Sir George Jessel, the Forest of Dean Coal Mining, and Russell and Wakefield Waterworks, and the decision of the Court of Appeal in Re Lands Allotment. Of course, the decisions of Sir George were extempore. Both of them dismissed claims brought against directors in circumstances where the defendants were hardly called upon. So there wasn't a proper argument, they were ridiculous arguments being thrown out peremptorily. But they illustrate a way in which these statements, perhaps casually made, about directors are being deployed. In the Forest of Dean Mining, a liquidator is suing a director to recover a debt which had been incurred years before the man became a director. The liquidator was proceeding under 165 of the Companies Act, which is an extraordinary piece of work. And if you think the federal draftsman or even the state draftsman these days is terribly sloppy, read this. A whole lot of people, including liquidators, can sue directors if they are liable or accountable for any monies of the company or have been guilty of any misfeasance or breach of trust in relation to the company, and then they can compel him to repay any money so misapplied or retained, or for which he's become accountable, or to contribute such sums of money to the assets of the company by way of compensation as the court thinks just. So it's broader than what I used to call Section 87 of the Trade Practices Act. All of the language of the section is very broad, very colloquial, the sort of thing that you'd get through Parliament faced with the awful corporate excesses of the mid-19th century. And the only one that really gets precise, or that precisely picks up legal language, is this notion of breach of trust. And it seems to proceed on the basis, statute compelling the conclusion, that directors who can commit breach of trust, and this is all about monies being misapplied, well, maybe, therefore, they must be trustees. So George Jessel put an end to that in Re Forest of Dean Mining. I set out the passages. The paper deals with the second Jessel case, and I'll skip over that, but I come to the third one, in Re Lands Allotment Company, a decision of the Court of Appeal. By this time, towards the end of the 19th century, legislation had enacted a limitation defence for trustees. We inherited the same thing here. And the directors who were being sued to recover money said, well, we should be treated as if we're trustees and we'd like to take advantage of this limitation period because this liquidator's been very slow. And the Court of Appeal made some statements confirming that directors were trustees of money which comes into their hands or which is actually under their control. But the context is about whether they can deal themselves into a statutory defence. It's not really saying very much about the basic way in which company monies are held by trustees. The paper then asks a question, well, is 165 a source of the concept of director as trustee? And I thought that was going to be very interesting, but not for the first time. Justice Gummow had beat me to the mark, and I refer to an article of his where he referred to earlier decisions before the 62 Act which picked up the same language, and in fact, it may well be that those decisions influenced the form of Section 165. Now, to go back to Selangor United Rubber, there's surely a much simpler analysis. Third parties who receive company assets from directors with a certain state of knowledge hold those assets on constructive trust, not because they were held by the directors as trustees. That can't be the case. The company is the legal owner of the company property, but simply because that's part of equity's response to directors who breach their equitable duties. Now, you may think, 30 minutes in, that I've spent a long time addressing a judgment of 55 years ago, but I've done so because very similar reasoning was in the UK Supreme Court less than 12 months ago. Lord Briggs summarised many of the cases that are discussed in the paper and then concluded as follows. He referred to the submission that, I'm quoting, a trust with a concomitant splitting of legal title from the company's continuing beneficial interests in the misapplied property occurred at the moment of the transfer which constituted the misapplication. Legal title passed to the transferee, but the equitable beneficial interest remained with the company. Therefore, the company retained the equitable interest sufficient to support a proprietary claim to the property or its traceable proceeds and a knowing receipt personal claim against any recipient. This submission best fits with all of the dicta summarised above. The analysis in Re Lands Allotment speaks of the trust arising when the misapplication of company property takes place. The same analysis is supported by Justice Millett. Justice Ungood Thomas is at pains to emphasise this as a real trust. And thirdly and decisively, Justice Buckley implicitly recognises a continuing equitable interest remaining in the company after the transfer. My approach to that is probably not very surprising to this audience after what I've already said. This is far more elaborate than we need. For centuries, directors have been misapplying company property. They were doing so before Barnes and Addy. Courts were responding to that before Barnes and Addy. We don't need to introduce a trust coming into existence a nanosecond before the fateful In Breach of Fiduciary Duty Act is performed. If you read the cases contextually, Justice Millett was dealing with a completely different problem, this notion that you can't have tracing at all unless there's a fiduciary obligation subsisting at the beginning. That's what his lordship was dealing with. Lord Justice Buckley was saying, politely, Justice Ungood Thomas is just wrong, treated as if a trustee. The most important point is that it's quite wrong to think that the liability of third parties who receive company property derives from these 19th century cases. It was obvious to Lord Hardwicke in the Charitable Corporation in Sutton. Directors of a company are fiduciary agents, as Justice Dixon called them, and a power conferred upon them can't be exercised in order to obtain some private advantage or for any purpose foreign to the power. Now, the paper then deals with other misuses by taking, which is worse than these, when you take words in decisions out of context, because at least all of these decisions were staying in context, dealing with company property being misappropriated by directors. A flavour of that can be seen from the closing paragraph, which picks up what the High Court said in Bathurst City Council and PwC Properties. They had a heading, trust in a non-technical sense. And they said that the question was whether a council car park was held or not held on charitable trust. They said that's not to the point. The question was whether it was land subject to a trust for a public purpose. It was easy for an advocate or a judge to see the word trust where it appears in a statute and leap to the conclusion that all aspects of the law of trusts themselves were loaded into that provision, and thereby to pass over the main issue, which may be the critical issue. Well, is there a trust at all, even though it says there's a trust? So let me tell you the conclusion of the paper, which has 5 points. First, there may very well be a choice involved in selecting the appropriate time frame for any historical account employed to justify a legal conclusion. And that choice may be contestable. The proposition that company law was born in the mid-19th century is certainly defensible, and sometimes that's appropriate. So in Westbourne Galleries, just an equitable winding up case, Lord Wilberforce explained how that power came not just from the 1862 Act, but from the 1848 Joint Companies Winding Up Act and the law of partnership. But contrast that with the controversial negative obiter suggestion in Farrer Constructions and Sadie, not my court's favourite case, where the High Court unanimously says, in recent times it's been assumed, but rarely if at all decided, that the first limb of Barnes and Addy applies not only to persons dealing with trustees, but also to persons dealing with at least some other types of fiduciary. Since the appellants didn't contend the first limb was incapable of applying, the correctness of this assumption need not be examined. And the footnote deals with some cases in the 1970s and 1990s. But it's quite clear from decisions going back at least to the 17th century, Charitable Corporation in Sutton, that persons dealing with directors of corporations or companies who take company property without authorisation or in breach of duty will have to account as constructive trustees. This predates Barnes and Addy. This, I'd suggest, is an area where a longer perspective is appropriate. Secondly, overwhelmingly often, the question in these cases is one of statute. Most questions of law which are free of binding authority, which are debated in any court, are questions arising under statute. And so I regret that my main example is Barnes and Addy liability. That should be regarded as an outlier. That's a pure question of judge-made law, but most questions of law are questions of statutory construction. And the 19th century cases, 165 of the Companies Act and the defence that a trustee might seek to avail itself of, they were statutory cases. So too was Lord Wilberforce's judgment in Westbourne Galleries. And can I give you a surprisingly modern passage from those reasons? Lord Wilberforce said, "There's been a tendency to create categories or headings under which cases must be brought if the clause is to apply. This is wrong. Illustrations may be used, but general words should remain general and not be reduced to the sum of particular instances." One reason for criticising reliance on 19th century cases when determining submissions concerning Barnes and Addy liability is that legal propositions resolving a question of statutory construction don't necessarily translate to the area of judge-made law. neither the term breach of trust in section 165 of the Companies Act, nor the same term when Lord Selborne used it to formulate Barnes and Addy liability, bears its literal meaning. And it's far from clear that a decision on the former will greatly assist the latter. Thirdly, while it's true that the 19th century cases used the language of trust to describe a director, many of them did so and made it quite clear that it was understood that the office was similar to, but distinct from, that of a trustee. There's a familiar passage from Clay and Clay, which is this: it's to be recalled that in the past the term trustee sometimes was used to describe the position of a director in relation to the company. Such a use of the term trustee could at best be metaphorical, because property of the company wasn't vested in the directors. In Knox and Guy, Lord Resbury said, "Another source of error in this matter is the looseness with which the word trustee is frequently used. The surviving partner is often called a trustee, but the term is used inaccurately. He's not a trustee. The application to a man who is improperly and by metaphor only called a trustee, of all the consequences that would follow if he were a trustee by express declaration, in other words, a complete trustee holding the property exclusively for the benefit of the CDK Trust, well illustrates the remark made by Lord Mansfield that nothing in law is so apt to mislead as a metaphor." And I was very pleased to see today that in the latest issue of the ALJ, there's a joint article on metaphors by Justice Gummow and Arian Massani. And I suppose I should say that I was the associate to one of those authors and the other is my current associate. But if metaphors are the most misleading aspect of language, similes come a close second. The decisions I've been talking about alternate between metaphor and simile. A director either is or is treated like a trustee. It's a subject for another paper, possibly a more interesting paper than the one you've just endured, about how those linguistic techniques are central to the way in which the law develops. But it's important to be careful and to understand the language of judgments in context, just as it's important to understand the language of statutes in context. Otherwise, there are mistakes in legal reasoning. Fourthly, Professor Paul Matthews, sitting last year as a High Court judge, commented in relation to a passage in a leading work about the law relating to executors and administrators being of some complexity and the need to understand history, said, quote, "To my mind, this is somewhat of a cheerful understatement." I love the cheerful in that. He added, after a careful examination of whether there was a separate doctrine of laches in probate, this passage: "Language changes, and society and the legal system changes too. There's a danger of misunderstanding both archaic language and superseded procedures. Thus, for example, the idea of praying a tales, as described by Dickens in the Pickwick Papers, chapter 34, would have been understood even by Dickens' lay readers, despite it being incomprehensible to most lawyers today. Yet even if words are sometimes unfamiliar and the institutions themselves change, the ideas with which lawyers deal may remain the same. And so too, praying a tales lives on as a legal concept in Section 6 of the Juries Act 1974, even though it rarely comes up. In some ways, the difficulties posed by the language of trustee in statutes and in judgments concerning the liability of directors are all the greater because the word continues to be familiar, unlike some ancient practice of summoning extra jurors. It's not just archaic language which poses a danger of misunderstanding. When a term like trustee continues but has a different and more refined meaning, then it's especially necessary to be alert to the way in which it was previously used. In the particular case of the liability of directors and third parties who receive company property improperly, the risks are heightened, in part because of the influence of the language of trustee in legislation, and in part because the liability we associate with Barnes and Addy preceded by some centuries the modern nomenclature, especially the notion of fiduciary, and judges rather casually use the language of trustee and quasi-trustee and trust property. When the judgments are read in context, the sense is clear enough, but if the passages are taken out of context, serious errors can ensue. Finally, parts of the complexity and nuance I've sought to emphasise recalls much of James Allsop's provoking paper, Thinking About Law, the importance of how we attend and of context, including this paragraph, which is from a somewhat different context, I hasten to say, which I recommend to you. He says, clarity, certainty, definition, and precise analysis are protected, not undermined, by an appreciation of the implicit, the uncertain, the ambiguous, complexity, and the limits of text when those matters can't be avoided. Not to appreciate and recognise these matters in thought and expression when they can't be avoided only creates a false and arbitrary so-called certainty, which gives a felt sense of artificiality in textual expression, but which crumbles against reality. I hope that's a useful antidote to the statement at the beginning of Lord Ungood Thomas's analysis in Selangor that the question was merely one of definition. Thank you very much for your time this evening.
Well, thank you very much. That was very interesting. It's certainly a complex area. I remember Justice Owen in the Bell and Westpac case saying he felt like he'd been locked in an oubliette. And in terms of, you talk about statute, my corporations law students who are here today will know that we really just talk about Section 79 of the Corporations Act and being involved. But I must say you've made the policy essay questions I write for corporations law exams look very lame.
I'm very sorry about that.
Perhaps I'll have to try something more complex. Okay, enough from me. Any questions? Otherwise I've got some. We've got some roving microphones. We've got one at the front, Katie.
Hello. Katie Barnett, Melbourne Law School. Thank you so much for that. I'm so glad that you pointed out that Barnes and Addy is as if they're a trustee, not actually a trustee, because it just drives me wild. One question I am wondering is, how do you choose, between proprietary and personal remedies, therefore, if you're treating someone as if they're a trustee?
How do you choose? I think the question is, I'm not sure whether you're a court or a plaintiff.
Yeah.
How do you choose between proprietary?
I guess it's... So if you're saying, because sometimes it's said that if you're a constructive trustee under Barnes and Addy, you've got a proprietary interest. And sometimes it's said you've got a mere personal interest. What do you think the principles might be?
It's a really good question. Thank you for asking, Katie. I think the starting point is to get the right perspective. What we're dealing with is a recipient of company property or trust property. We're dealing with the nature of their liability. We're dealing with how amenable they are to orders of the court requiring them to account. From a plaintiff's point of view, a plaintiff may have, as many beneficiaries suing trustees have, a choice, and they are perfectly entitled to be self-serving about it and say, we want the proprietary remedy. We don't want you merely to account for the $200,000 you took away from the company. You bought NVIDIA shares. We want the shares, thank you very much. And there may also be times where there's no property at all, and I may be overstating it, but there are certainly some suggestions in some of the English legislature that the absence of a continuing proprietary interest denies a beneficiary accountability of these third parties in equity, and that just seems wrong. So if you frame it in terms not so much of following a piece of property that has to be in existence every nanosecond of the way when you're dealing with someone who hypothesised breaching their obligations, and you ask a different question, what is the nature of the way in which equity requires these guys to account? and say, in many circumstances, it will require him or it to account both personally and proprietarily, perhaps at the choice of the plaintiff, but there may be other factors depending upon defences, then you get a more satisfying answer to the question. Is that a sensible response to your, or a partial response?
Okay, any other there's a question up the back, Miranda, and then... I think it's good we've got questions, because my question was probably a bit mean, which was about taking it a step further, charitable companies and whether they hold assets on trust, which was something that Harold Ford wrote on. But I won't put you on the spot with that one, because it's a super mean one. So Miranda.
Miranda's going to put me on the spot about tax. I'm favouring.
I think I'd like to hear the answer to that question too, so you don't come out just because I've got a different one. So it is very interesting, the method of history, as you say. You did also say, and I know you're talking in a particular context about understanding judicial decision-making, I suppose, and you've referred to, although you also intriguingly referred to statute, but you did also say that the timing and the kind of where you start the narrative or history is contestable. And so it does then beg the question as to what kind of justification is required by the person who's going back in history. You know, at what point do you stop? So in some ways it's impossible to answer, but obviously one does stop sometimes. And I guess does that still, that's useful for critiquing layers of judgments and layering and accretion of language, as you say, over time. But in the end, you still perhaps need to think about policy of the law and actually intent. And of course, I operate mostly in the world of statutes. So history is useful, but what also are its limits? So two elements there, I guess.
So I'm not sure what the question is, but I agree. And so would Cardozo. Cardozo would say this is only one of the four things in the progressive courts. So he was talking about defending very progressive decisions that had recently been made by his court, in their toolkit to change the law. And one of the problems of limited time is that you get the sense that the things they're focused on are all exhausting. And I go back to the second thing, this is complex. So Cardozo would not say, and I would not say, that an historical approach is going to give you the answer in any case. It might help you get to the answer, but of course you're looking at other things as well. From a court's point of view, the other thing which I'm conscious of, and it's not just from a court, from an advocate's point of view, what happens when your opponent comes up with some clever, well-researched, seemingly persuasive historical account that means just that the most natural thing is, and yes, I have to win. You have to remember that advocates are paid not to uncover historical truth. They're paid to win cases. The historical research is not disinterested. And it's going to come to a grinding end if the advocate feels it's not helping. So it's not a disinterested historical inquiry, and often we get disparity of arms and you don't get the full picture. And that's not a criticism, it's just the way the litigation game works. So that's a further limitation upon courts using the self-selecting, skewed historical material that a cunning advocate may deploy as one strand of their argument. But the main point is, I do not say that's the answer by any means. I do say, however, also that if you don't have regard to it, then you may slip into error. It's complicated.
Very complex.
Judge, thank you for the talk. I'm curious to understand that this conceptualization of directors as trustee, does it vary according to the management structure that the company adopts?
Question. I'm just having difficulty hearing the question.
I want to understand that this conceptualization of directors as trustee, does it differ according to the management structure that the company adopts? Is there a distinction between the conception of a director as a trustee when it's a professionally managed firm having dispersed shareholding and a controlled firm which is run similar to a quasi-partnership, something like that?
I do understand the question, and it's a good one, thank you. It's not something the paper delves into at all. It's dealing with companies at a much higher level. It doesn't deal at all with the ways in which contract, the terms on which a director will hold office, can subtract from what would otherwise be his or her duties, and the extent to which statute will permit contracting out. There's a deal of, it depends on what jurisdiction you're in, by the way. There's a deal of liberality, but there are some things you can't contract out of. But it's, so you're a person who, if that's the question you want the answer to, shouldn't waste his time reading this paper when it comes out.
We've probably got time for one last question. We're certainly making you work very hard. Do we have one last question? Oh, up the back.
Thanks. Thank you for the talk. In your discussion of the paper, and I look forward to reading it, you mentioned a distinction between company law and the etymology of association and corporate law with the etymology of body or an entity in various jurisdictions. Did you find in your research for the paper that distinction in nomenclature actually led to a distinction in substantive case law or statutes, or is it simply just historical sort of accident that you know different areas of law in different jurisdictions get described as different things?
The short answer is no. I didn't see substantive difference. The longer answer, though, is that I do feel very deeply that legal reasoning necessarily takes place using language. And so the labels that we give to legal concepts are really important. And whether we call something estoppel or unconscionability or a common intention trust as opposed to something else really matters, because it shapes the way in which novel legal consequences seem more or less plausible. And that, frankly, was my interest, a main aspect of my interest in it, but it didn't go anywhere. But it's a question that goes close to something that I do feel very strongly about. If you really want to know, it comes from experiences about 3.5 decades ago when I was studying pure mathematics. And the goal in pure mathematics is to come up with something that no one, not even those clever classical Greeks, or anyone in the last 3.5 millennia had come up with before. And then, says my supervisor, the most important thing you can do is name it. And that will shape its future. And I think it's true of maths. It's certainly true of maths. I think it's true of law as well.
I've been told it's true of book titles as well. But thank you so much. I'm pleased to hand over to Andrew Walker now from Clayton Utz.
Well, thank you, Professor Langford, and let me also acknowledge the generous words of Dean Foster and Emeritus Professor Ramsay earlier. On behalf of Clayton Utz, I'm honoured indeed to propose this vote of thanks to His Honour Justice Leeming for a most illuminating and insightful presentation this evening. We are certainly indebted to Your Honour for giving of your valuable time, particularly having travelled from north of the border, and joining us in continuing the finest traditions of this event in honour of the late, great Professor Ford. We are doubly indebted to Your Honour for standing at the fork in the road and, notwithstanding Your Honour's Herculean workload, I'm sure, choosing the path of serious scholarship over judicial homily. Like most, if not all of those present, I very much look forward to digesting Your Honour's 12,000 words. It sounds like a rich dramatist person awaits with 15th century statutes, ecclesiastical law, Oxford University, micro-lending in the 18th century, and last but I suspect not least, a Russian Tsar. We can only hope for some reference to the pure mathematics to which Your Honour referenced. I'm sure Your Honour will forgive me if I say that I probably won't get to it before January, and possibly not all in one sitting, but I do look forward to it. It's a rare thing indeed to encounter a true expert in both disciplines, given the expansive body of jurisprudence in company law and the law of trusts. I suspect for many of us, including yours truly, our earliest acquaintance with such an expert was none other than the late Professor Ford. Not just a superb lecturer, but the author of the two seminal texts of the era in both disciplines, The Principles of Company Law, now under the reliable auspices of Emeritus Professor Ramsay AO, for which we're very grateful indeed, and The Principles of the Law of Trust, both of which became a gold standard of reference for both students and practising lawyers alike. Indeed, a dog-eared copy of the 1995 edition, complete with its invaluable, then invaluable dual references to both the Companies Code and the just enacted Corporations Law, still sits proudly on my own bookshelf. You're of course well aware that Professor Ford had a very long association with this university's law school, serving as the chair of commercial law from 1962 until 1984. For 10 years thereafter, we at Clayton Utes were incredibly privileged to have him join our then fledgling Melbourne office as a consultant from 1985 to 1994 inclusive. I can do no better than to confirm and respectfully adopt the recollections of Your Honour's learned wife. Indeed, I strongly suspect that I may have been one of the nerds loitering in the general vicinity of the great man's office, whom she faithfully recalls. I should perhaps confess that was only after my first introduction to Professor Ford in the Clayton Utes Library in the late 1980s, after I complimented our then and still current librarian, Janice, on how useful her assistant had been on a rather arcane query. I could tell from the expression on Janice's face that I'd committed something of a faux pas, and I added, to my shame, you know, that elderly gentleman in the cardigan. Her discreet, but not discreet enough stage whisper said, "That's Professor Ford." But of course, he was incredibly good about it, and notwithstanding his greatness, he was a wonderful, kind person of great generosity and humility. So we're enormously grateful to Your Honour for kindly continuing the fine traditions of this event in memory of Professor Ford. And could I please invite all present to demonstrate our appreciation to His Honour, Justice Leeming, in the traditional fashion.